You're listening to Colorado Chamber Office Hours, a podcast that explores what matters most to business. I'm your host, Ed Sealover, Vice President of Strategic Initiatives for the Colorado Chamber of Commerce and editor of the Sum and Substance. Let's get talking. Welcome back to Colorado Chamber Office Hours. And as we're welcoming you, the listeners, back, we also want to welcome back a familiar face, Representative Yara Zokai of Fort Collins. And this week, Representative Zokai is here with us to discuss House Bill 1236, which is scheduled for its first hearing on Tuesday. Welcome, Representative Zokai.
Nice to be back.
Thank you. Well, now, House Bill 1236 is, in its simplest description, an arbitration reform bill, but I feel like that description undersells it significantly. There's a lot of details I want to talk through with you, but first, let me just ask, why are you and Representative Javier Mabry targeting arbitration in this bill as a practice that needs reform?
Well, look, arbitration has been an alternative dispute resolution measure for a long time, and it will continue to be an avenue that people can pursue in order to have a dispute resolved. We're very well aware of that. We understand that arbitration is a dispute resolution option that many people do like. However, we have also seen the prevalence of arbitration as a compelled form of dispute resolution really increase over the last few years. So before, it would be the type of thing where two parties agree to have an arbitrator who might have specialized expertise on a subject matter help resolve a dispute. Now what is happening is compelled or mandatory arbitration provisions are in nearly every contract we sign. And it has become something that people are very unaware of and yet is taking away their right to go and have a dispute resolved in court. And so while that is happening, we want to make sure that while arbitration is being compelled, it's still accessible and fair. And there are unfortunately bad actors out there that use this as a way to tip the scales in their favor.
You mentioned that arbitration clauses seem to be omnipresent these days. Which kind of particular arbitration clauses or what kind of contracts do you anticipate that this bill would impact the most?
So this bill is focused on employer-employee contracts as well as consumer and merchant. So there are situations where arbitration might make sense. You might be in a very specialized field. You want to have an arbitrator that can understand your unique situation and have some sort of technical background. I think that it makes sense in those circumstances. Does it make sense every time you are signing up for a Disney Plus or a gym membership or going to work? I don't know. But while that is happening and is not something that I'm able to change. While that is happening, I want to make sure that if arbitration is mandated, that people can actually go.
And to kind of beat down on that a little bit, you mentioned kind of the Disney Plus, the gym. What kind of employer-employee situations often are required to go to arbitration?
There are, in many times in employee contracts, very broad mandatory arbitration provisions saying that if there is any dispute between an employee and an employer, that it must be settled through arbitration. Lost wages, discrimination. There's a wide range that these provisions can cover, and they do.
Okay, great. That sets the ground really well there. So how then does this bill, and there's a couple provisions I want to narrow down on, but I'll ask broadly to start. How then does this bill kind of remove the specter of forced arbitration? What does it do to those clauses?
It very simply does not touch those clauses. That is mostly preempted. So the Federal Arbitration Act really does rule over all arbitration enforcement and whether these provisions can or can't be in contracts. I personally do think there needs to be reform in that space. I think people need to, at the very least, understand what they're signing because these are hidden within pages of terms and conditions that people really do not know what rights they're signing away. But that is not something that at the state we have jurisdiction over. So those provisions are here to stay.
So it doesn't remove those clauses. What does it do then to make arbitration more fair?
It does a few things. So for one, it says if we are compelling a party to go to arbitration, it should not cost them more to initiate that process than it would to go to court. Most good actors in this state, which is the vast majority, do fall within that. And it is comparable to a federal or state court filing fee. However, there are some that have these exorbitant fees. And so not only have you forced somebody to only have arbitration as their remedy, you have made it so cost prohibitive they never can actually seek it. So for one, it says that those fees must be comparable. It also says that if an arbitrator is discriminating against a party, that they can get a different arbitrator. And what I would hope is that parties would, if they're compelling arbitration, give multiple options of arbitrators. And I'm going to throw Ticketmaster under the bus here, who has their own in-house, well, I guess they would call it completely separate from them, arbitration firm that they created. And that is who they go to have their disputes resolved. And of course, they say it's fair and impartial, but I think that a consumer might not feel that way. And so that really brought this idea of we should let people have choices on who their arbitrator is if they are required to go, at least 3 to 5 people to choose from. That is actually also preempted, so we are not able to require multiple choices. What we have said is if there is discrimination, you should be able to seek a different arbitrator.
How does that work, though? I mean, who gets to judge, or maybe in this case, be the arbiter of whether somebody is discriminatory in their history? And how do they, is this like the jury strike system where you get to get rid of so many of those? How does that work? Who decides that?
That's a very good question. We actually discussed that perhaps you'd go to arbitration to discuss who the arbitrator should be. I think that you could potentially also go to court and say, this is in violation of the state law that recently passed, and I should be able to get a different arbitrator. But as many things, disputes are now resolved through arbitration. So there could be a provision requiring any disputes of arbitration be settled in arbitration.
There are levels of irony to that, but
Yes, there are.
I'll let that stand there. Let me go back to the previous one you mentioned about the comparative cost of arbitration. So if somebody is asking too high a fee for arbitration, what happens then? Do they have to automatically knock down their fee, or is there a case that could be made that you're asking too high a fee, this arbitration is invalid?
The case that this bill is making is that if your fees are prohibitive, that you are no longer able to compel arbitration, that somebody should be able to go to court. And so I would think that the remedy will be that the fees will be brought in line to those court filing fees. But should somebody who is compelling arbitration just refuse to make those fees in line with court filing fees, then yes, that court remedy is now available.
Okay. Just to geek out on that one, because I've had people ask about that. How do you compare the fees? Is it just the initial filing fee for arbitration versus the court, or do you start looking at having to pay the arbitrator and how that compares to the cost of going to court as well?
It is the initial cost to start arbitration. There's typically some initial filing fees, and there's agreements over who pays how much of the arbitrator's fee as well. So whatever that total initial cost to initiate the process should be the same as the initial cost of whichever court you would be filing that claim in.
Okay, great. And I cut you off when you were talking about the discriminatory arbiter provision. What other aspects of this? There's the fees. There's the discriminatory arbiter. What else does this do?
And there is also a piece around the actual payment once a decision has been made. So many times there is a decision made that the prevailing party needs to be paid a certain sum from the losing party. And unfortunately, there are some bad actors in the state that have made it their standard practice to just not pay, because the remedy then is that a party would have to go to court and compel them to pay. And they know that an arbitrator doesn't have enforcement power essentially to make them actually make good on that commitment or make good on that decision. And so it's become standard practice for some larger corporations to say you must now go to court and file a judgment to enforce your decision. And so this entire process that was meant to take things out of the court is now putting more filings in the court. And because they know that that's prohibitive for a lot of people, a lot of consumers are not going to be able to then go take an additional step and navigate the court system to compel a judgment. So this says that if you are doing that and you are not actually paying your obligation within 30 days of whenever you are supposed to pay it, that you are liable for additional damages.
Okay. Big picture picture, what do you expect the impact of this to be? And I'll start by saying I know that you have said we can't overturn federal law in the requirements of these arbitration clauses, but will this lead to less arbitration? Will it just lead to better outcomes? How does this affect consumers, employees, etc.?
So this bill does not, in my mind, lead to less arbitration. It makes it so arbitration is a remedy that can actually be accessible for people. As they're being forced, as this is their only path forward to have a dispute heard, it is to make sure that they actually can then do that and maybe feel like they had a fair process. Maybe we'll never get people to truly feel that way, but I want to put safeguards in place so that can be a fair process that people can actually use.
Okay. Well, we'll be curious to see how this discussion goes. Representative Yarazokai, thank you again for talking with us about
Thanks
this
so much
bill.
for your time. This is great.
And now we will flip the conversation around, and we are talking with Julian Ellis, a partner at the First and 14th law firm and an expert on arbitration, who is going to point out what he and others believe are some of the worrying aspects of House Bill 1236. Mr. Ellis, welcome to Colorado Chamber Office Hours.
Thank you, Ed, for having me.
Well, first, for those who don't deal with this subject, tell us exactly how common arbitration clauses are in contracts and what kind of contracts you tend to see these pop up in.
So I think arbitration for at least the last 50 years has become ubiquitous. We often see these in sophisticated contracts between sophisticated parties, and they have become common in what this bill covers, which is employment contracts and consumer-facing contracts or merchant contracts as well. And so I think any given consumer or out there could look at a number of their contracts with the various service providers that they have, and they're going to find an arbitration agreement. So they are common, have been common for a long time, and as we'll talk about, I think beneficial to both the consumer and to the businesses who use them.
And you kind of read my mind there. Tell me why people would prefer to go to arbitration rather than taking every dispute through the court system.
Well, as a litigator who litigates in the court system on a daily basis, it can be time consuming. Our courts, particularly here in Colorado, are burdened. The caseloads are higher than they've ever been before. And the time from filing to final judgment can stretch on for years. Arbitration presents a streamlined, very efficient process that is outside the court system. It is through a private arbitral institution most of the time. And so there's efficiencies to be gained. So you're going to get, justice or a resolution a lot quicker. The statistics actually show that consumers actually do better in arbitration as well. You can imagine some of these consumers may be pro se. A pro se litigant who's representing themselves is going to have a harder time navigating the ins and outs of the civil justice system in the courts than a private kind of more bespoke system that is set up for a little more flexibility through the arbitral institution. So I think it's a win-win.
So as you look at this then, and we'll kind of break down several aspects of this bill, but what do you think the overall impact of this bill would be on the arbitration process, on the ability of consumers or employers or businesses or anyone involved in these contracts to use arbitration?
Well, quite candidly, I think the first layer result will be mass confusion. I think the bill is written in a way that is not very clear in its application. And you have to keep in mind that this bill is proposing to amend a Uniform Arbitration Act. So uniform in the sense that this is a multi-state act that policymakers have said is good policy. And it doesn't exist in isolation. It exists with other state laws. It exists also with a federal overlay. We have the Federal Arbitration Act that has been on the books for a long, long time. And we have a string of U.S. Supreme Court cases in the last 20 years re-emphasizing over and over and over its preemptive effect on state law. And so I think the first, while the bill, I think, proposes to, make the process more friendly and allow or open the courthouse doors, I actually think it's going to bog down the process a lot more, because you're going to be fighting over, well, does the Federal Arbitration Act apply? Is it preempted here? Is it not? Those are all issues that are going to be played out over months, perhaps years in courts before you ever get to the substance of the underlying dispute.
So do you feel this could actually run afoul of federal law?
I do, and I think the proponents of the bill have recognized that in Section 1 and 2, trying to get out in front of any preemptive effect. The problem is that it's more a recognition than any type of application or express exemption. And so you're still going to have litigation over, well, does the Federal Arbitration Act apply? The Supreme Court has said that the Federal Arbitration Act should be interpreted consistent with the Commerce Clause, or at least even broader than the Commerce Clause, and which is very broad. And so, if you have, for instance, a telecommunication contract, say through Verizon with a consumer in Colorado, well, is that state specific? Is that an an interstate agreement? The service is being provided maybe outside of the state of Colorado. So does the federal act apply? Does the state act apply? All of this is going to have to be litigated, and it just ultimately delays ultimate resolution, if that's the true aim.
So you're saying we could be litigating about the ability to litigate before we even go to litigation in some ways.
That's correct. And this is not a hypothetical. The city of California has tried over decades to tinker with arbitration reform and has repeatedly been struck down. I think I'm up to maybe 5 U.S. Supreme Court cases where they've come in and said, no, you can't do that. Colorado is on the same trajectory if this bill becomes law.
Now, speaking of litigation, do you feel like this will push more cases to court rather than to arbitration, which seems to be the aim of the bill? And if so, I'm curious your perspective, what that's going to mean for both the judicial and maybe even the business ecosystem in Colorado.
Well, I think there's two kind of components working here. No doubt it's going to push more litigation to court. That is the express desire and aim of the bill, is to remove these disputes from arbitral fora and move them to the court system. But again, there are going to be threshold legal questions that have to be resolved, and it could be that initially a collective action is filed in federal court, then the business who is the defendant in the case files some type of removal action or to compel arbitration. There's litigation over that. It bounces back and forth. And so, it's going to create more work for the court system just to get to go. The second component of this is, oftentimes these are smaller dollar disputes. And, like it or not, our court system isn't the best forum to litigate and decide these smaller dollar disputes. Those are best done in a private setting like arbitration.
And speaking of smaller dollar, and I'm flipping through the bill while I'm listening to you here, there's an interesting clause in here that prohibits a provision in an arbitration agreement that requires an employee to an employer contract, and a consumer to a merchant and consumer contract to pay fees, and I'm reading this directly, to pay fees that are substantially exceeding the costs required to file a claim in state or federal court. First of all, tell me your interpretation of what this means. And is this clause so broad that we don't quite understand what the term fees means? Are we talking just about the initial filing fees? Are we talking about the fees to pay the arbitrator, as you certainly don't have to pay a judge to overhear things?
That's a great question. And this is just another area that we're going to be litigating. That's why they pay us lawyers, well to quibble over what the word fee means. But I'd say that what this provision seems to be intending to do is almost create kind of a foot-foul situation where you have an arbitration agreement. It perhaps has some type of fee requirement. It doesn't match up perfectly with the filing fees in the court system, and you're not anticipating like being in court and there's some type of dispute under the agreement 10 years later, and now you're in court and you're trying to match the fee schedule in the court and the fee schedule in the arbitral institution. You're saying, aha, one's higher than the other, we're going to court. But there's also a practical point here too, and that is, in a lot of these consumer facing contracts, the businesses really try to make it fair. Oftentimes these contracts are one-sided against the business. In other words, the business says, we think the arbitral forum is the best place to resolve this dispute. We recognize that it is not a public service like the court system. We will pay for it. Or you're required to pay for it up to an amount. And so, my opinion is this provision is really tilting at windmills a bit.
There's one other provision I'm really curious about, too. It's one that essentially seems to disqualify arbitrators with a demonstrated pattern of conduct that violates neutrality. Is it clear exactly how this will work and what violates neutrality?
So there's been several efforts over the years to target arbitral institutions and arbitrators specifically, and their disclosure requirements, etc. I really do not know how to apply this, and frankly, I think that's the point. If it can't be applied, or at least applied principally and consistently, there's less of an appetite to incur those costs and go through the arbitration process. And keep in mind, all the reputable, established arbitral institutions, they already require these disclosure requirements. Arbitrators are often, almost 100% of the time, are former judges. These are judges who have spent careers on the bench serving the public, and now they're doing the judging in a private institution. No one knows these rules and the principles of fairness and balance more than these folks, and they do a good job. Are there a few bad apples? Yes, they're the exception to the rule, and there's already mechanisms in place in the Uniform Arbitration Act to handle that. But what this does is it just throws sticks in the spokes to slow the process down, to create confusion. Maybe this particular arbitrator has decided another dispute for this bank, and is that a demonstrated pattern of conduct against a party or a type of party? Who knows?
Who knows seems to be the theme of this. There are a lot of questions that this bill brings up and it, at least in our guest mind, doesn't seem to answer. And I think next week we're going to watch to see how many of those questions may be answered at a legislative hearing or how many of them may still be hanging out in the air. Julian Ellis, thank you so much for coming on and talking with us about this effort at arbitration reform.
Thank you, and look forward to watching this bill.
That's it for our interview segment. Now let's take a quick look at what you need to know about the week ahead. So, what's happening this week at the legislature? Well, first up, there's the arbitration reform bill that we've just spent the podcast discussing. It's up on the upon House adjournment schedule on Tuesday in the House Judiciary Committee, which meets in House Committee Room 107. Now, while I previously referred to these upon adjournment committees as morning committees, the debate on nearly everything on the House floor has gotten, shall we say, vociferous. And this bill is fifth on the agenda. So I'd suspect it's either very late morning or more likely early afternoon on Tuesday when this bill will get its hearing. FYI, the Colorado Chamber and other business groups are in opposition to the measure for many of the reasons that Julian Ellis stated. Also on Tuesday, the Senate Finance Committee will take up Senate Bill 137, second on its 2 p.m. agenda. This bill is arguably the highest priority this session for the Colorado Chamber of Commerce, a measure sponsored by the leaders of both caucuses in both chambers that would seek to make regulatory and rule reviews more frequent and more thorough in an effort to determine if there are rules that can be pulled back without endangering public health or safety. The hearing is scheduled for Senate Committee Room 357. Just in case you need more to do on Tuesday, the House Health and Human Services Committee will hear House Bill 1267, which limits the ways that healthcare providers can collect medical debt. Or at least I think it will hear the bill, as it's already been delayed twice in the past 2 weeks. This is also an upon adjournment committee that will be meeting in House Committee Room 112, and the bill is third on the agenda. This is also a bill that is opposed by the Colorado Chamber and other business groups out of concern that it will limit the ability for hospitals to collect money that is owed to them for services. Speaking of bills you've heard before, Senate Bill 8 is once again scheduled for a hearing Thursday afternoon before the Senate Health and Human Services Committee. This is the bill that would create a new mental health service, new mental health enterprise, I should say, to give more access to in-person and telehealth behavioral health care, but that would do so by charging a fee to everyone in Colorado who purchases internet services. The bill is scheduled 8th in the 1:30 p.m. committee. Yeah, you heard that right, 8th in the old Supreme Court chambers. And finally, one of the biggest things happening this week will be House discussions of the budget. The budget is scheduled to be introduced Monday, in committee by Tuesday, and debated on the floor Wednesday and Thursday. The Joint Budget Committee is looking to close a $1.5 billion budget shortfall, which will make these discussions very dicey and very interesting. Business leaders are looking at things like whether they will recommend that the state privatize Pinnacle Assurance for a budget balancing fee of around $400 million, a move that Governor Jared Polis wants but that Pinnacle has not yet agreed to, and whether hospital leaders will whether hospitals will take a big bath on Medicaid services, which is one of the ways that Governor Polis is recommending closing that budget shortfall. Stay tuned to the Sum and Substance, as I will be watching all the action closely. That's all for this episode of Colorado Chamber Office Hours. Once again, I'm Ed Seelover, Vice President of Strategic Initiatives for the Colorado Chamber of Commerce and editor of the Sum and Substance. I'll keep the conversation going at tsscolorado.com, and we'll see you next time as we explore the issues that matter most to business.